Megan, would you please call the roll for us?
Regent Menedietz.
Here.
Regent Prince.
Here.
Regent Rye.
Here.
Regent Salzwedel.
Here.
Regent Tyler.
Here.
Regent Walsh.
Here.
Have a quorum.
Thank you. Before we start, could I remind everyone to mute their phones so we're not having that interruption while we're in the middle of these proceedings? Thank you. This is the meeting of the Board of Regents Personnel Matters Review Committee. We're here today to hear arguments on the matter of Chancellor James Beattie's recommendation to dismiss Dr. Joseph Gow, a professor at the University of Wisconsin-La Crosse. Both parties have been informed of the process we'll follow today. Each party will have up to 20 minutes to have their arguments presented, beginning with the attorneys representing Chancellor Beattie. Each party will then have 10 minutes of rebuttal, again, starting with the attorneys representing Chancellor Beattie. We will be keeping track of the time, and I will let parties know when they're approaching their time limit. I think it's going to be on the screens in front of you. After both parties have finished rebuttal, there will be an opportunity for committee members to ask questions. The committee will then move into a closed session to deliberate without parties present. A few reminders for both parties before we start. Your arguments should be based on the record created before the University of Wisconsin-La Crosse Faculty Hearing Committee. I can assure you that we've all reviewed that record. You should limit your arguments to addressing Chancellor's recommendation to dismiss Dr. Gow for just cause. There should be no questions directed to the committee. Finally, you should address your arguments to the committee and not to the other party. Let's get started. 20 minutes for arguments by attorneys Lattice and Harrison. Please begin.
Thank you very much. Good afternoon, Chair Menedietz and members of the Personnel Matters Review Committee. On behalf of the University of Wisconsin-La Crosse, I would like to thank all of you for being here and engaging in this process. As board members volunteering your time, I know that providing service of this nature is a substantial undertaking, and the work you're contributing is greatly appreciated. We contend that under UWS-4, the board should find just cause to terminate Dr. Gow, professor at UW-La Crosse. The board has long applied the just cause standard of Safransky versus Personnel Board, a 1974 Wisconsin Supreme Court case. Under Safransky, just cause to terminate employment exists when a tenured governmental employee's conduct can reasonably be said to have a tendency to impair the employee's performance of the duties of the employee's position or that of the efficiency of the group with which the employee works, or is so substantial, oft-repeated, flagrant, or serious that the employee's retention and service will undermine public confidence in the employer's service. The record establishes just cause to terminate Dr. Gow's employment. Dr. Gow has violated administrative code, university policies, and undermined the trust that the university once had in him. In its decision issued on July 11, 2024, the UW-La Crosse Faculty Senate Hearing Committee, Active Hearing Committee, unanimously determined by a 5-0 vote, which is rare, that the university had established just cause to terminate Dr. Gow from his faculty position. Consistent with this recommendation, following a meeting with Dr. Gow, Chancellor Beebe forwarded a recommendation for termination to President Rothman. UW-La Crosse requests that the PMRC recommend to the full board that Dr. Gow be terminated. Based on the briefs filed by Dr. Gow, his core argument is that his conduct at issue is protected by the First Amendment and that it is unlawful for the university to terminate his employment because the university's interests do not trump Dr. Gow's interests. The university disagrees. This issue is squarely addressed in our briefing, but I will highlight a few points. This case does not involve academic freedom. At no point has Dr. Gow ever claimed, at least not seriously, that his pornographic videos, insubordination, computer misuse, or unethical conduct were academic endeavors. Gow's pornography videos are not protected by the First Amendment because they are not, under Roe versus San Diego, a public employment case with similar facts to the current case, a matter of public concern. The NTEU case cited by Dr. Gow is inapplicable to Gow's case, just as the U.S. Supreme Court made clear it was inapplicable in Roe. The Seventh Circuit Harshfager case Gow relies on is distinguished from Roe and distinguished from Gow's behavior. Harshfager did not make pornographic videos for sale like Gow and Roe. She wrote a book about being a telephone sex operator prior to working for the government. Unlike Gow and Roe, Harnisch-Fager had little public interaction in her job, and there was no information that, assuming her work was of public concern, that the book was disruptive to the functioning of her office. Gow, in contrast, is the former chancellor of UWL and now a professor, who outed himself by posting content on readily accessible websites like Xhamster and Pornhub. During the Sex Party podcast, which is Exhibit 107E from the university, from approximately minute 21 forward, Gow admits that he got the idea to place the content on these more public sites during a conversation with a producer who works in the porn industry. And his content went from getting very few hits to over 250,000 in a couple days just on a single video. This happened well before the board terminated him as chancellor. In his own words from the Sex Party podcast, quote, "So we put them on there, and it was like stunning. In a number of days, we got 250,000 views on one video. And then apparently somebody who knows us saw the stuff, and they told the people that I work for, and then all hell broke loose. We really didn't think we would be uncovered and outed so quickly and dramatically." Gow is a public employee, and his pornographic videos are legal, but they are not protected speech in the context of Gow's public employment. Even if Gow's speech was protected, the university could still lawfully terminate his employment under a Pickering-Connick balancing test. Finally, Dr. Gow was insubordinate. This provides a separate basis from termination apart from the pornography production. In the opening paragraph of his brief to this committee, Dr. Gow asserts that, quote, "The University of Wisconsin-La Crosse was motivated in its termination efforts solely and exclusively by its unhappiness with Professor Gow's sexy, happy couple videos, and that Dr. Gow's purported violations of university policy and its evaluation of the evidence of those issues was driven by its animosity towards Professor Gow's First Amendment protected speech rather than by any genuine concern for its reputation, its computer use, and other policies." You may be wondering what evidence Dr. Gow submitted during the hearing to support this argument. There is none. His argument has no basis in fact and ignores the findings of the faculty committee. Neither Dr. Gow's initial nor reply brief seriously acknowledge, much less discuss, the evidence submitted by the university or analyzed by the faculty committee in reaching its unanimous recommendation to terminate Dr. Gow's employment. To help set the stage regarding facts developed during the hearing, I will refer to page 6 of the faculty committee's decision, where the committee's comments included the following. The committee found quote, "The committee found that Professor Gow to lack credibility with respect to disputed issues of fact. Professor Gow provided explanations that range from being plausible to evasive to disingenuous. During the hearing, Professor Gow made statements that directly contradicted statements he had made in media interviews and that were incorporated into the record. UWL believes that all statements and arguments from Dr. Gow should be viewed in this light. Through his own actions, he has eviscerated his own credibility. The arguments advanced by Dr. Gow in his briefs are no more credible than the testimony before his peers on the faculty committee. Let's discuss some of them. On page 4 of his opening brief, Dr. Gow asserts UWL failed to prove that Dr. Gow's actions damaged the reputation of UWL, and at the hearing, UWL provided no evidence or witnesses to show Dr. Gow's actions adversely affected the reputation of UWL. Remarkably, Dr. Gow seems to suggest that the university must suffer irreparable harm from his presence in the classroom before it can take steps to prevent that harm from taking place. Where is the law that supports this assertion? The court in Roe did not require the city police department to wait until its reputation was irreparably tarnished before it could remove Officer Roe from its ranks. Also, this assertion ignores the hearing record, including testimony from Dr. Morgan, that explicitly discussed the increased workload for UWL staff to counter the negative effects Dr. Gow's activities were having on the campus, including negative comments or complaints from prospective parents, former students, legislators, and donors demonstrating that Dr. Gow's actions were harmful. Dr. Gow asserts that UWL failed to prove that he engaged in unethical or illegal behavior. This is ridiculous. The faculty committee pointed out that Dr. Gow's pattern of behavior demonstrating poor judgment while acting as a visible and recognizable member of the university faculty committee violated several applicable UW regulations and policies and identified those clear policy violations. As we now know, Dr. Gow had a business relationship with Ms. Hartley when he brought her to campus in 2018 and failed to disclose that information. The faculty committee noted that 6 years after the event, Dr. Gow continued to display a lack of accountability for that act. Dr. Gow admitted to multiple acts of illegal conduct in his book, Monogamy with Benefits. The book included statements such as all events described are true. Conveniently now asserting that all events may not be true is not credible, supported by the evidence, or consistent with additional admissions Gow has made during his numerous media interviews, including during the first 7 minutes of the Sex Party podcast. The faculty committee was unmoved by Dr. Gow's attempted reframing of his admissions. Dr. Gow misunderstands the Ethics Code, Chapter 8. The university did not try to show that Gow violated subsection UWS 8.052 because it did not have that evidence, perhaps in part because Dr. Gow refused to participate in the investigation process. However, under UWS 8.025 sub 1, no staff member may engage in outside activities that conflict with their public responsibilities to the universities of Wisconsin, whether remunerative or not, whether related to an academic field or not, whether on one's own time or not. Dr. Gow's activities violated this subsection. The faculty committee noted that once a faculty member publishes provocative content and is recognized in it as the public face of the university, he must choose whether to respond in a way that supports the best interests of the university as his employer or capitalize on the controversy. Professor Gow clearly chose the latter path, exploiting his role as a UWL faculty member and former chancellor to generate additional interests and views of and revenue from his pornographic content for his own benefit. Dr. Gow introduced no evidence at the hearing refuting the evidence introduced by the university on these points. Regarding the charge of insubordination, in no uncertain terms, Dr. Morgan directed Dr. Gow to participate in the investigatory process by participating in an in-person interview, and he refused. The university absolutely may require Dr. Gow to sit for an investigatory interview. He does not get to choose the format. The university is not required to accept an employer's proffered alternative to answer questions in writing. Gow's refusal to sit for the required interview was plainly insubordinate, as Dan Shannon explained at the hearing. Also, universities of Wisconsin employees travel extensively for work purposes, including international travel. There's no valid reason Dr. Gow did not participate. Remember, he was paid approximately $50,000 during the spring semester, and his sole assignment was to participate in the investigatory process. He refused to do so. It should be noted that he did find time to travel to Mexico during this period for a vacation. See UWL Exhibit 108, page 1. There's a picture of Dr. Gow on a beach with a beer and cocktails with the caption, "Taking a little break today from pornography and politics. Hashtag sex positive, hashtag vegan." See also UWL Exhibit 108A, pages 7 through 9. The faculty committee summarized it well. Professor Gow's limited engagement during the investigation deprived the university of the opportunity to find out more information that may have affected the investigation report and ultimately the statement of charges. Finally, Dr. Gow argues that UWL failed to prove that he violated the acceptable use of information technology resources policy. The faculty committee again disagreed. Specifically, the committee found that there were dozens of vendor emails in Dr. Gow's email work account for sex toys and other sex products that included graphic pornographic imagery, that Dr. Gow had previously used his work email account to purchase 2 books regarding pornography, that in November 2023, Dr. Gow printed a co-performer consent release form for the X-Hamster website, and that credentials to log into pornographic websites were saved on 2 university-issued laptops. Throughout this case, Dr. Gow has argued under the assumption that everything he said in argument at the hearing is evidence. It is not. The only evidence introduced at the hearing came in the form of witness testimony and documents. Gow's inconsistent arguments were not evidence and were properly disregarded by the faculty committee fact finders, as they should be by the board. It is the unanimous opinion of the faculty committee and the chancellor that there is just cause to dismiss Professor Gow from his faculty position based on a clear preponderance of the evidence. This is not a criminal case that requires meeting a beyond the reasonable doubt standard. During the June hearing, UWL administration noted that it is Dr. Gow's repeated poor judgment that has led us to this point. He just didn't seem to get it during the hearing, and the briefs he submitted to this committee indicate that he still just doesn't get it. Dr. Gow spent the first 3 pages of his reply brief reciting the UW freedom of expression policy, beginning with a quote regarding academic freedom. This case has nothing to do with academic freedom, and Dr. Gow was not speaking on a matter of public concern. In his initial brief, Dr. Gow asserted that UWL failed to show that Dr. Gow placed himself in the public eye regarding his hobby. That is a crazy assertion. Dr. Gow published 2 books about his hobby, predicted that scandal would ensue if his activities became public, and clearly admitted on the Sex Party podcast that his own decision to place content on Xhamster, Pornhub, and similar sites resulted in minimal hits to over 250,000 hits in a couple of days on a single video. Once fired, he then chose to and continued to choose to promote his content and engage in extensive media interviews. Dr. Gow has worked very, very hard to place himself in the public eye. Particularly for someone who previously served as chancellor, Dr. Gow's behavior has been unethical, hypocritical, and unacceptable. His attempts to deflect continue. The Nina Hartley matter was not his fault. It was how others reacted. His decision to publicize his hobby last fall isn't the issue. It's the way that he was fired by President Rothman and the board that was the real problem. As chancellor, he was responsible for enforcing rules and policies on campus. Now he thinks it's acceptable to disregard them. Though actually, I suppose we now know that he thought it was fine to quietly ignore certain rules as chancellor as well. He claims his actions have not harmed the university. It is the response by the university that has somehow drawn attraction to this matter. Dr. Gow can simply not be trusted, and certainly not trusted in a classroom. As I stated at the conclusion of the hearing, Dr. Morgan and others provided ample testimony demonstrating what has only become clear during this entire process. Dr. Gow just doesn't get it, or is unable to acknowledge that his conduct has been harmful to the UWL campus community and a distraction from its core mission. Dr. Gow has largely gotten what he wants through this process: a large media presence that continues and a great marketing opportunity for his cooking and adult content. It is time to bring this matter to a close. University of Wisconsin-La Crosse respectfully requests that Dr. Gow's employment be terminated for cause. Enough is enough. Dr. Joe needs to go. Thank you.
Good afternoon, members of the committee. I appreciate your service here and appreciate your attention as we address these most serious legal and factual issues. Our request today is that this committee reject the recommendation of the UWL faculty committee that Dr. Gow's employment be terminated. And the central reason supporting our request to that effect is that this is a First Amendment case that involves punishment for the content of speech. You can't get closer to the core of the First Amendment than that. It takes place, as my opponent noted, against the background and the backdrop of the Regents' own publicly professed commitment to the values of free expression. You know what those are. You abide by them. I'm not going to review them here, but I do want to remind you that that is the background of this proceeding that we are engaged in today. We don't need the First Amendment to protect the Star-Spangled Banner. We don't need the First Amendment to protect easy and comforting speech. It's exactly the opposite. We need the First Amendment precisely when the danger of stifling controversial, unpopular speech is at its highest, and that's what we have here in this situation. The most important question here is what standards apply, and I think I will be able to show you when we talk simply about the good cause standard applied on its own, that the university has not met its burden, but it's got a much bigger burden to meet in this instance, and that is the burden imposed by the First Amendment. We talk about the NTEU standard. It's discussed extensively in the briefs, and I do want to review legal issues here because they are very, very important, because they are the framework that we hang the facts on. The NTEU standard for evaluating for evaluating whether a public employee's speech is protected by the First Amendment begins with a three-part test. First part is it must be made outside the workplace. There is no serious dispute that this speech was made outside the workplace on Dr. Gow's own time. Second, it has to be content that is largely unrelated to the employee's governmental position. Not entirely unrelated, the Supreme Court tells us. It tells us largely unrelated. And again, whether you believe the assertion in the university's case that there's a passing reference to Dr. Gow as chancellor in one of these videos, certainly there is no extensive identification of his position. There is no detailed exploration. It is not in any way remotely like the case from the Seventh Circuit, the Craig case that involved the guidance counselor, nor is it remotely like the Doe case, as I'll get into some more detail, the police officer case out of San Diego. Here, the third element of the NTEU test is whether there is a public audience or it's a matter of public interest. And this does not require that this be some sort of lofty debate about issues of political philosophy or issues of importance to everyone in society. It is simply an inquiry into whether there are people in the public who are interested in it. Is it a topic that is seen as important by people? And there is no doubt that sexual conduct is a matter of importance to people. It's a matter of vital importance. The Supreme Court has recognized that going way back to 1957 in the Roth case. It is a matter of vital importance not only in sexual conduct, in how to promote healthy and stable marriages. Simply because Dr. Gow's views on what promotes a healthy and stable marriage, healthy and stable monogamy, do not comport with the views of the majority of society, that doesn't matter. In fact, it requires an even greater degree of solicitude because, again, we don't need the First Amendment to protect what's popular. We need the First Amendment to protect what is not popular. There is no doubt that there is an interest in vegan cooking. There is no doubt that there's a public interest in the adult entertainment industry. The fact that some people are uncomfortable, many people, even an overwhelming majority of people, may be uncomfortable with the discussion of these topics in detail, is of no moment in deciding whether or not there is a matter of public interest. Clearly, under the law, there is. In the Harnischfeger case out of the Seventh Circuit recognizes that the public is interested in sexual matters, and that's just a fact. It is interested in the adult entertainment industry, in a sex-positive lifestyle, and in whether marriages are what best promotes healthy marriages and monogamous relationships. It's not at all a private debate between Joe Gow and the administration about governance. These are matters that don't have to do with his position as a professor at all. It is not obscene. No one can credibly argue that it's obscene, and even the Hush-Blackwell report acknowledged that it is legal pornography. There is no showing here in the next step that there was a link by deliberate steps by Professor Gow between the content of his videos and his employment. The test is that you cannot deliberately trade on public employment. A good example of what does meet that test we find in the Doe case out of San Diego involving the police officer who made videos of himself while wearing his police uniform, engaged in sexual conduct and in parodying police officer gestures and actions. Another case that shows what does deliberately trade on public employment is the Craig case out of the Seventh Circuit involving the guidance counselor. In that case, he emphasized in his book, throughout his book, emphasized his role as guidance counselor, used numerous examples of cases involving, and his theory was, of course, that women are always to blame for relationship problems. He used numerous examples of his students in the things that they had told him in his work as a guidance counselor. Even had one of his colleagues write the foreword to the book. Extensive ties throughout the work. Nothing like that here. Nothing that rises to the level of the instances that the courts have found are sufficient to say that there is some sort of deliberate link to employment. And then that brings us directly, when we reach this point, now we get really to the crux of this case, which is the balance of whether UW correctly concluded in its faculty committee vote that the interest in promoting the efficiency of its public services outweighed Dr. Gow's interest in exercising his First Amendment rights. And we respectfully submit here that the UWL struck the wrong balance. It's not enough to speculate. It's not enough to rely on rumors or maybes. It's showing either actual disruption or a fact-based belief that there is going to be future disruption. And what facts do we have here about disruption? We don't have much. I want the regents, if I may indulge here, to take formal notice of UWL's announcement this week that it's about to welcome its largest ever entering class. Surely if the publicity attendant to Dr. Gow's activities were impairing UWL's good name, that wouldn't be happening. You might take the position, as UWL did in its briefs, that maybe there hasn't been irreparable harm yet, but sure, if we let him back in the classroom, that's going to happen. That's just speculation. That's guessing. It's not even well-formulated speculation. One thing that I noted as I reviewed the record that was assembled before the committee at UW-La Crosse is that it was simply the testimony of the former interim chancellor, Morgan, about what people were telling her, the concerns that were being raised to her by faculty, by alumni, students, et cetera. And I understand they didn't bring in anyone like that to testify. But they certainly could have obtained written statements. They could have gotten affidavits. They could have gotten something to say, look, we have a groundswell here. We have numerous people who have approached us. And this is just a snapshot of that. We didn't get that. We got the unsupported speculation of one administrator's forward-looking, not looking at, because certainly the reaching the high point historically of enrollment is completely inconsistent with any kind of adverse effect that was supposedly created by Professor Gow. We don't have anything to back up what the administration predicted would be happening. No statements by anyone. They didn't come in to testify. They didn't bring anything in writing. No parents, no students, no donors, no legislators, no alumni. All those people, whatever they had to say, came in through second, third, fourth-hand information. And even if they had, you can't automatically credit it. You have to test it. And there isn't anything here that suggests that there has been any sort of anything resembling short-term, medium-term, or long-term harm to the university. What it is, instead, is factors that really cannot be considered when we look at the law, and we can't consider things like, well, we're embarrassed. We disagree profoundly with the things he's saying. He's making us individually look bad, look silly. Those aren't things that count under a balancing analysis. They just don't. No doubt there are members of the public who are offended by Dr. Gow's videos. They may have included legislators, parents, alumni of UWL. But even that can't go far enough to show that he should be fired, that the balance weighs in UWL's favor. There are members of the public who are offended by faculty speech on any number of issues. It might be pornography. It might be the state of war and hostilities in Israel. It might be on the presidential election. There can be all sorts of things that are offending people that faculty members say well within their First Amendment rights. And it is not the job of UWL or of this Board of Regents to police those things, especially in the absence of significant and definitive evidence of harms that are going to take place in the future. We rightly recognize that free speech and expression can't survive, let alone thrive, if speakers are required to worry about whether they will offend people in power. There is seriously nothing placed in the balance by UW here that rises above the level of speculation, and they pretty much admit that on page 14 of their brief, where they phrase it conditionally. If Professor Gow continues to teach, it could adversely affect funding, enrollment, et cetera. Again, that's just based on the interim chancellor's summary of things that she says people told her. I do not believe that this panel should afford that testimony a whole lot of weight. Even under strictly applying the just cause standard and the state court cases that are discussed extensively in the materials, in the briefs that were submitted by UWL, there isn't enough here to carry UWL's burden. First of all, again, I'm not going to reread what counsel said. He accurately stated the standard from the Safransky case, which has been applied numerous times since 1974. But I do want to call attention to the distinctions between the cases that they cite and the facts of this case here, even if you do find those facts to be credible and to have been properly found. The cases that the university relies on all involve conduct that is significantly more egregious, and I think that if there had been a case that showed conduct like Dr. Gow's resulting in termination and affirmance of that termination by the court system, we would have seen that cited in the briefs. We have for example, in the Burton case, there was a tenured professor who was terminated after she was recording confidential personnel discussions of the university and posting them on the internet. She posted false, inflammatory, non-factual content on her website and on social media, and directly abused colleagues in person and through email, intimidating and harassing them. We don't have anything like that here. In the Martyr case, a tenured professor was dismissed, and the courts upheld the termination on a factual record that the professor had shared a hotel room with a female student and been so drunk he did not remember whether he masturbated in front of her, pursued a personal relationship with another foreign student with whom he shared hotel rooms, and again, engaged in sexual behavior in front of her, made false statements to an auditor who was looking into the finances of the student newspaper he supervised, and made direct false accusations about the conduct of university administrators and letters. And finally, in the Yao case, which is from the oldest of the cases that they cite, well, Safransky is actually the oldest, but Yao is the oldest faculty case. There was a tenured professor who was fired because the university saw and heard and, among other things, saw on videotape that he had intentionally tampered with a colleague's laboratory materials. That, again, all three of those situations go significantly beyond the conduct that UWL has introduced into the record here. I do say that there is no reason to believe that any of this investigation would have been done. I think it is notable that even before the termination and this investigation were announced, the university had already taken possession of Dr. Gow's computers. I think it is notable in this regard that the expert that was called to testify by the university could not say that Dr. Gow had himself accessed these pornographic websites using these login materials. I think it is significant that we heard a lot of emphasis on insubordination and the refusal to be interviewed. And what we did not hear was that Dr. Gow had repeatedly said, I am willing to be interviewed. I would like to wait until I have counsel. FIRE, the organization, the Foundation for Individual Rights and Expression, is trying to find counsel for me. Can we please defer this? And they never told him any reason, well, we need to do this now. There was never any reason given. There was simply a refusal to acknowledge that. And I think it's notable that the state, that the university here did not mention the fact that he wasn't simply blowing off the university. He was waiting for counsel to be appointed. I have some other things to say about their argument, but I will save it for rebuttal. Thank you very much.
Thank you. Rebuttal, please.
I should be pretty quick here. I mean, the majority of the argument set forth has to do with the legal argument. We have largely briefed that, and so I won't, try to delve into there. What we heard very little of is actually applying the facts of the case, to law or any sort of explanation as to why Dr. Gow's behavior is acceptable. On insubordination, there's a suggestion that he was somehow summarily dismissed or, the investigation just went on with no notice. We respectfully refer you to the exhibit submitted by UWL. There is a clear chain of communication from Dr. Morgan to Dr. Gow, directing him to participate, warning him explicitly that he would be deemed to be engaging in insubordinate conduct if he didn't do so, and he refused to do so. I understand potentially perhaps trying to wait for free legal counsel, but as Dan Chanin also explained, it isn't uncommon in HR investigations to give someone a day or less notice, or let's say 1 day notice, to say we expect you to appear to be present for an investigatory interview. He had roughly 6 weeks. He's a very sophisticated employee. He's a former chancellor. He didn't want to get locked into statements because once you're locked into statements in an investigative report, you can rely on those. We saw at the hearing that the panel found him to lack credibility because there was direct conflict between statements he's made in all of his interviews and what he tried to put forward there. We've heard no explanation as to why having a prior business relationship with Ms. Hartley, failing to disclose that using university funds to pay her was somehow ethical and appropriate. We've certainly heard no spin on why violating the terms and conditions of his prior chancellor employment agreement was somehow acceptable and ethical. And I don't think as the board, even though we're talking about him previously being chancellor and now a tenured faculty member, you can ignore that. It is very common in an employment situation to look at the entire arc of employment. He demonstrated he was not to be trusted as a chancellor, and he's continued to demonstrate he is not to be trusted as a university employee. They talk about the lack of evidence. Again, this is a preponderant standard. And the university introduced live testimony, documents, etc. Dr. Gow introduced virtually nothing. The committee has the right to say, based on the evidence introduced, We find it credible and believable. We find the university's case credible and believable. That is what they did. There are no legal infirmities in the evidence that the university introduced against Dr. Gow. In terms of the computer use, again, the committee reached its conclusions based on the evidence that was offered. This is, I understand that Dr. Gow would love to, try to rely on a hyper-technical First Amendment argument to get around his bad conduct and the need for the university to separate ways with him. He did not convince the committee. He refused to cooperate in the investigation, and now in part he wants to try to rely on his failure to cooperate to say that there are infirmities with our case. Well, had you asked me X, Y, or Z, we wouldn't have to wonder about a lot of answers if he had actually cooperated, if he'd given information. And again, we maintained that he did not cooperate because he did not want to get locked into statements. And again, he should not benefit from that. Dr. Gow should be terminated from his employment, and UWL respectfully makes that request.
I have just a few remarks. Number one, one thing that we did not hear from UWL was that Jennifer Lattis, seated here at council table, actually did interview Dr. Gow on December 20th, sat down and did talk to him about some of these matters. Obviously, it was at a very early stage, but to say that he was completely unwilling and digging in his heels about that, he did sit down and talk to her. They wanted more, and they may well have been entitled to more, but there is no explanation here as to why the accommodation that he requested could not have been granted, or at least explained to him why it couldn't have been granted. We heard, I just heard, I think, that the First Amendment is a hyper-technical argument. I hope that this panel believes it's something more than a hyper-technical argument. It's not a hyper-technical argument. It goes to the heart of what we're all about in this state and in this country. The benefit, the parties actually stipulated as to the monetization of the videos that Dr. Gow was producing. The monetization, the parties stipulated to that, and they stipulated that that did not occur until until January of 24. January of 2024, Gow and Wilson began receiving earnings from viewings of the videos. Before that, it wasn't happening, in large part because this had not, the termination of his position as chancellor had not received the public attention that it had received. In all, I think that this panel is entrusted to carry out the function of following the dictates of the UW System Administrative Code, and as well as following the requirements of the First Amendment to the United States Constitution. And we believe that if the panel does that and carries out that work with dedication and good faith, it will reject the recommendation of the UWL committee that Dr. Gow's employment be terminated. Thank you.
Thank you. We now will have a time for the committee members to ask questions if they have any. Regents, do you have any questions? Okay, I guess we have no questions from the regents. So we thank you for your professionalism and your arguments. They were well presented. Now it's time for us to go into closed session to consider the information and to deliberate regarding the dismissal for just cause of the UW faculty member Joseph Gow, as permitted by section 19.85, parent 1 close parent, parent A close parent, parent B close parent, and parent F close parent of the Wisconsin statutes. May I have a motion?
So moved.
Second?
Second.
Megan, could you conduct the roll call?
Regent Manydeeds.
Yes.
Regent Prince.
Yes.
Regent Rye.
Yes.
Regent Salzwedel.
Yes.
Regent Tyler.
Yes.
Regent Walsh.
Yes.
Okay. I'll give you a chance to clear out before we start our deliberations. Thank you.
We'll be happy to talk down there.
Well argued, sir.
Thank you, sir.
If you'd like.